Hello, I'm talking now about pure economic loss and voluntary assumption of responsibility. So if you voluntarily assume a responsibility, that can be used to show this proximity and therefore a duty of care is extant. This comes from an undertaking expressed or implied by the defendant who is exercising care in providing counsel or guidance. But there's been some doubt voiced about this. There's some criterion whether it's needed or whether it's utile at all. In Smith and Bush 1990, in the appellate court, Lord Griffiths said that it was really worthless when we were trying to find liability. In Henderson against Merit Syndicates Limited 1995, Lord Gough said that the castigation of this notion of voluntary assumption of responsibility in the case was misplaced. So some people think it's a worthwhile component. So when does liability arise? Well, there's been a lot of debate about negligent misstatements, and it usually looks at trying to find whether there is a duty, but you mustn't disregard the defendant is only liable if there's a lack of care. If you pay due care and attention, if you're diligent and get it wrong nonetheless, then you're still in the clear, because you can't 100% guarantee you're correct. So you might have done everything you can to check it out and still it was wrong. But a lot of advice on economic matters turns out to be mistaken, but it's not careless, because economics is not an exact science, and then black swans sometimes come across our path. The defendant has the chance to explain the limitations of his knowledge, and the data is limited in its granularity and all the rest of it, then that can be judged as still being sound advice. You have to demonstrate that negligent advice or information caused the claimant's loss and not something else. So to whom is a person liable? The loss might be experienced someone other than those to whom the advice was given. There were two rulings in the House of Lords which seem to contradict each other, Smith and Bush, and the other one is Caparo Industries against Dickman, 1990. So there are vital social situations. Smith, a house buyer, wanted to get a mortgage from a bank, and he sued the surveyor who had been commissioned by the lending institution to provide a report, which the purchaser paid for, and the report was given to the bank about the condition of the property. The surveyor was found to hold a duty to the buyer and not only to the bank, even though the purchaser had not been advised about the necessity or the sensibleness of getting a survey. Anyway, but hadn't done so. Caparo, an accountant's firm, they did a statutory order of a company, and they were held to owe a duty of care to the shareholders as owners of the company, but not to the claimants who were trying to take over the company on the basis of the accounts. Lord Bridge said what's vital here is proximity in the situations. If a statement is put into general circulation, they have to prove this. The defendant knew that his statement would be communicated to the claimant either as an individual or as a member of an identifiable class, specifically in connection with a particular transaction or transactions of a particular kind, and the claimant would be very likely to rely on it, close quotation. So that specificity limits liability seriously. So look at the different approaches that can be adopted in these cases. You bear in mind the number of potential claimants in either case and the social importance of these different situations. Then there's the Caparo test. So a duty can come about through a Caparo situation. There's a relationship between a claim and the purpose for the auditor's report is close enough, so there's proximity. The decision has been interpreted as showing some components which are there, some conditions to satisfy, and these can be expressed as a list of three in the Caparo test. The test for the duty of care is, first of all, the loss must be reasonably foreseeable. Second of all, there must be proximity. And third of all, it must be fair, just and reasonable to impose the duty. So you have to think about policy considerations in number three. Caparo, in that case, a report was supposed to allow shareholders as owners of the company to decide if they were happy with the management by the board of directors on the basis of the company's previous performance. It was not there as a decision to invest the shares of the company. Advice about investment will be on different criteria altogether. So there was no voluntary assumption of responsibility to the potential investors, and it wasn't reasonable for investor to rely on the report for that purpose. So James McNaughton Paper Group Limited against Hicks Anderson and Company 1991, Morgan Crucible PLC against Hill Samuel Bank and Company Limited 1991, or the Law Society against KPMG Marek 2000. These are all also relevant cases. So remember, reliance can be by a third party, but that's enough at the moment.